Hello CA Aspirants, welcome back to our channel CA Aspirants Comfort Zone. Today we'll be revising complete law for exams May 25 and onwards. Let's start with the chapter Audit and Auditors. The first auditor should be appointed by BOD within 30 days. In case of government company, CNAG will be appointing it. Penalties for contravention will be penalized under section 147. Form CRA 2 intimating appointment of another cost auditor. Section 144 is for punishment for contravention. Section 145 power to sign audit report. Section 142 remuneration of auditors. Who will be necessary to appoint an auditor? Applicability of the auditor. Every listed company should appoint an auditor. Unlisted company, if paid up share capital is greater than or equal to 10 crores. If a private company, then it should be greater than 50 crores. Turnover greater than or equal to 100 crores. Outstanding loan is greater than 50 crores in any part of the financial year. Exception is for joint venture, wholly owned subsidiary, dormant company. For appointing an auditor other than the retiring auditor, special notice should be made. Firm can be appointed for 5 years. After resolution, it can be appointed for 5 more years, that is 2 consecutive terms of 5 years. It can be appointed as auditor for the same company. Appointment of auditor in a single chat. First auditor, if other than government company, first auditor can be appointed in 30 days by BOD from incorporation. If not, then next the shareholders will appoint in given 90 days. If it is government company, first the opportunity will be given to CNAG in 60 days. If they don't appoint in 60 days, the board of directors will be appointing in 30 days and shareholders will appoint in 60 days if BOD didn't appoint. Here we'll remember shareholders will appoint in 90 days, but here it will be given only 60 days as we have given CNAG also 60 days. Tenure is till the conclusion of first AGM. If it is a subsequent auditor, we saw here the first auditor appointment, and if it is subsequent auditor, we'll be discussing for other than government company in the below sheet. For government company, 180 days from start of financial year by CNAG. CNAG will appoint within 180 days. No other options for BOD or shareholders. If it is casual vacancy, 30 days BOD will be appointing a new auditor. Resignation, 3 months shareholders. Ordinary resolution should be passed. Tenure, next AGM. For government company, CNAG will be appointing within 30 days. If not, BOD will appoint within 30 days. Tenure till the conclusion of next AGM. We saw the subsequent auditor, the point will be discussed below. That means before appointment, auditor shall give written consent and certificate stating eligibility, terms, company's terms and conditions are followed within limit, that is 20 companies, exceeding 1 person, dormant, etc. companies. List of proceedings disclosed is true and complete. The short form is LET proceedings. L stands for limit, E stands for eligibility, T stands for terms, proceedings stands for list of proceedings disclosed is true and competent. This should be given to the company by the auditor. Then he'll be appointed as auditor. An appointment, company shall file ADT 1 within 15 days to ROC. body corporate for NAFRA in 15 days. Retiring auditor may be reappointed if he is not disqualified, not expressed unwillingness in writing, special resolution not passed, providing expressly that he shall not be reappointed, appointing some other auditor. Okay, now let's see about the disqualifications of auditor, that is section 141. Body corporate, an officer or employee of the same company, person who is partner of the company, a relative of partner or partner holding any security. A relative may hold up to 1 lakh securities. If exceeds, take corrective action within 60 days or else he'll be disqualified. Holding of all relative, we have to consider the total relative, not single should hold 1 lakh amount of. Here we should notice that that is face value, not the market value. All relative will be included, and then we'll conclude if he is able to become an auditor or not. Indebted for greater than 5 lakhs, guarantee or provided security greater than rupees 1 lakh. Business relationship, direct or indirect, except transaction in arm's length. Arm's length means in case if we buy some products, that should be the price which he'll be selling for the other customers also. There should not be any less price or discounts just because you're going to be the auditor of the company. Or professional service, whose relative is director or KMP, full-time employment elsewhere, maximum 20 companies. We discussed there. Once again we'll see which all the companies will be included and which will be excluded in count of 20 companies. It will exclude OPC, small company, dormant company, private company whose paid up share capital is less than 100 crores. The short form is DOPS, DOPS, and that is dormant company, one person company, private company and small company. Firm, each partner 20 per person. If there are 4 partners in a firm, the total company they can be appointed as auditor is 4 into 20, that is 80. The limit will be of 80, not 20. Convicted for fraud and 10 years not elapsed as per section 141. These things should be followed. If he doesn't fall in these points, then he'll not be disqualified as an to appointed as auditor, and he'll be eligible to become an auditor. If occurs after, he should vacate, then that will be concluded as casual vacancy. Next, the first auditor in case of government company, CNAG will be appointing in 60 days. If failed, BOD will appoint within 30 days. If failed, members will appoint within 60 days. In private or other than government company, BOD will be appointing in 30 days. If he fails, members will appoint within 90 days. We have seen this, but we will be seeing this in detail in the chat form. In case of casual vacancy, it may be because of anything. The auditor might have a dead, or he might be disqualified, as we saw in these points. He might be if these things has occurred, the section 141 has occurred and he's been disqualified as an auditor, then that will be creating casual vacancy. In that case, government company CNAG will be appointing within 30 days. If failed, board of directors will be appointing in 30 days. If other than a government company, BOD will appoint within 30 days. If by resignation, general meeting within 3 months of recommendation of the board. Removal of auditor. in case if they want to remove the auditor because of any reasons, these steps should be followed. Removal of auditor by special resolution. Special resolution should be passed, that is 3/4 of the members should agree. Previous approval of RD as per Rule 7. Application to RD in Form ADT2 with the prescribed fees. Application is made within 30 days of resolution passed by the board. Company shall hold general meeting within 60 days of receipt of approval of RD for passing special resolution. First, the form should be, the application should be filed to RD. Next, after 30 days the resolution has been passed, within 60 days they have to keep a general meeting. Then in the meeting where special resolution has been passed, the auditor will be removed. Before removing the auditor should be given opportunity of being heard. After resignation, auditor shall file a statement in Form ADT3. The section for foreign company is 2 subsection 42. Okay, now let's come into the question parts. Who is not required to prepare cash flow statement? The short form is DOPS. That is dormant company, OPC, private company, small company. If options are given like this, you have to analyze for each type of company and then write which suits for the above company. Public company can issue shares only by issue of prospectus or refund. In case if that is proven that the issue was made without issue of prospectus, then they should refund the money. Share capital can be increased or decreased by passing special resolution. Allotment of private placement should be made within 60 days or repay in 15 days with interest of 12% from expiry of 60 days. Which all the documents the listed company should submit to ROC and with whose sign? Within 60 days, Form MGT 7 of AGM or to be held. It should be given not only if the AGM is conducted, but if there was a time where the AGM was to be conducted and was not made, but within those time, that is within 60 days, the company should file MGT 7. Sign should be of CS with certificate of practice, with certify the above facts that those are checked and those are correct, with MGT 8 from company secretary, with the form MGT 7 should be given. Company can restrict rights of shareholders in the following situation. In case of non-payment of calls due on shares, non-payment of other dues, company has exercised lien on shares. This is for public company, and for private company, the private company can provide more restriction if it is provided in the AOA, that is Articles of Association. EOTing will be given in the chronological order, that is in case of joint holders, the first name that has been appeared in the list, the first name will be given the opportunity to vote. Open for not less than 3 days and close at 5 p.m. on the date preceding the date of general meeting. That means if the general meeting is on the 15th, the e-voting should be stopped on 14th evening, that is at 5 p.m. Within 5 p.m. the e-voting should be closed and it should be open for 3 days, that is on 12th, 13th and 14th. These 3 days it should be open and it will be ending on 5 p.m. Which are the company that are considered not listed even if they have listed some of the securities? Let's see what are those. First, public company. Equity shares have been not listed but have listed non-convertible debt securities on a private placement, non-convertible redeemable preference shares. This will not be considered as listed. They should compulsorily list equity shares in the platform, then it will be considered as the listed company. Private company, listed non-convertible debt. Public company, equity shares have been not listed in recognized stock exchange but listed on jurisdiction. This will not be considered as listed company. These are public and private company. They'll not be listing in that. So non-convertible debt, even if it is listed in the stock exchange, will not be considering those as listed company. Okay, what is a small company? The most favorite question of ICI and also the students of ICI. The section is 2 subsection 85. Small company is a private company whose paid up share capital is less than or equal to 4 crores, and in case of prescription it can be increased up to 10 crores by central government, and the turnover does not exceed 40 crores, which can be increased to 100 crores in case of prescription by central government. Nothing in clause shall apply to. The short form is S, S and S, that is S cube. That means a subsidiary or holding company, section 8 company, and special act, company or body corporate under special act. In case of entrenchment, in case of entrenchment in any clause, to alter it, public company shall pass special resolution, that is 3/4 should agree. In case of private company, all members approval is necessary to make changes in case of entrenchment. Trademark Act is 1999, section 8, contravention of company already registered. Promoter. Who is promoter? The short form is PACA, that is prospectors whose name has been mentioned in the prospectus, whose name has been mentioned in annual return, control affairs of the company, advise BOD other than professional authority. The short form is PACA. Prospectus, annual return, control affairs of company, advise BOD other than professional authority. Next, let's see what is dormant company. Dormant company is a company where no significant transactions have been made, or the company registered for future handling of transactions. Documents to be filed to register 1% company, that is OPC. First, memorandum of association, declaration of compliance, declaration from subscribers to memorandum, address for correspondence, particulars of the subscriber, particulars of persons mentioned in the articles, particulars of interest of persons. Conversion of OPC to private or public company. Alter memorandum of association and articles of association. Increase number, that is in case of a private company it should be increased to 2 or more. In case of public company it should be increased to 7 or more. File application in INC 6. If satisfied, registrar will examine audited financial statement, then he'll be issuing certificate of conversion, that is in case of private or public company. What is section 8 company? Section 8 company is a company who has the objective of a promotion of commerce, art, science, sports, education, research, social welfare, religion, a charity, protection of environment, etc. Intends to apply profits to promote objective. Intends to prohibit payment of any dividend to its members. To be valued certificate by the company. The certificate should be signed by 2 directors of the company and seal 1 director or 1 secretary, company secretary, that is CS. In case of no CS has been appointed to the company, then 2 directors should sign. 2 directors should sign and company seal should be attached in case of any seal has been maintained. Who can be member and who can be nominee of OPC? OPC member or nominee, they should be compulsorily Indian citizen who has been stayed in India for 120 days. The number of days is 120 days. What is indoor management? Indoor management protects outsiders from internal proceedings. Exception is knowledge of irregularity, acts forgery, no knowledge, negligence, act outside the scope of apparent authority. In these cases, indoor management will not be applicable. Constructive notice, because AOA and MOA are public documents. This is for the company's point of view. This is for company's benefit, and indoor management is to protect outsiders. This is to protect company. Serving of documents. How it will be, how the documents will be served and when it will be considered good. It should be served through registered post or speed post, courier services, leaving it at its registered office, other electronic modes as may be prescribed. Alteration of AOA. Special resolution should be passed. Filing of alteration with registrar. Any alteration made shall be valid. Alteration noted in every copy. Alteration of clauses. Resolution of BOD, that is special resolution, should be passed. Filing with ROC. Entry in registrar of companies. In case of listed companies, a special resolution should be passed. Notice to shareholders. Publication in newspaper. One in vernacular language, that is local language that is being followed. Example, in case of Karnataka, will be following Kannada newspaper, and one English newspaper. Placing on website of the company. Opportunity to dissenting shareholders. Then company file copy of SR with ROC, certify within 30 days. In what cases the securities premium account can be used? Securities premium account can be used to issue bonus shares, writing of preliminary expense, write off expenses, commission, discount, etc. Premium payable on the redemption, purchase of its own shares, that is buyback. That is buyback. In case of buyback, premium payable on redemption, writing of expenses, commissions, discounts, etc. Preliminary expenses to issue bonus shares, securities premium account can be used. Member and nominee of OPC shall be natural person, Indian citizen, irrespective of non-resident Indian citizen or resident Indian citizen, and 120 plus days in India. Time given is 180 days to fill vacancy of nominee in case the nominee resigns the company by giving notice to OPC as well as ROC.